We've just published our latest paper on issues that tenants and landlords face before and during a tenancy. It highlights common issues that come up when people are looking for a home to rent, when people are entering into an agreement to rent a home, and during the time that people are renting a home. Some common issues that came up were discrimination. While other laws may apply before the creation of a tenancy agreement, generally speaking, the Residential Tenancies Act does not have rules about tenants' applications or how landlords select tenants. While the Alberta Human Rights Act prohibits discrimination against tenants or potential tenants, we heard that it is not entirely effective for many reasons, including lack of knowledge, difficulty interpreting or applying the law, and problems with enforcement. Personal information and information about a property. There are no rules regarding the information that can, should, and must be exchanged between tenants and landlords. The Personal Information Protection Act applies to landlords and the information they can collect. However, the rules are drafted very broadly and can be confusing. There are also no rules covering what information about a property a tenant is entitled to. Residential tenancy agreements. These can be written, oral, or implied, but we found issues with all forms. Oral or implied agreements are vague, with landlords and tenants having disagreements over very basic things like the amount of rent, when it is due, and when it ends. Written agreements can also have problems when they contain terms that are contrary to the Residential Tenancies Act. Security deposits. Security deposits can be a frequent source of conflict between landlords and tenants. Some sources of this conflict include what a security deposit is for, who owns the security deposit, what a landlord should do with a security deposit, how a security deposit is returned to a tenant, and what happens to an unclaimed security deposit. Rent. Specifically, what is considered rent. For example, some agreements show an amount payable as rent, but also show charges a tenant must pay for amenities like storage units or parking. It is unclear if the remedies landlords have for recovering unpaid rent apply to these additional charges. Utilities. There are no rules in Alberta's Residential Tenancies Act when it comes to utilities. Most issues arise because of disputes over the cost of utilities and how they are paid. Fees and penalties. The Residential Tenancies Act does not address fees in any helpful way. The definition of rent is broad enough to include any fee that a landlord charges to a tenant. Other jurisdictions in Canada have much more specific laws when it comes to fees. Some places prohibit application fees or late payment fees. Other jurisdictions only limit late payment fees, yet other places have rules for various other types of fees like fees for guests, move-in or move-out fees, or fees for subletting or assigning a residential tenancy agreement. Other fees are not mentioned in the Residential Tenancies Act, but courts and tribunals in Alberta almost always find them unenforceable, including late payment fees, lease break fees, or clawbacks of rental incentives. Behaviors and rules. Both landlords and tenants tend to agree that the rules managing behavior are important to any tenancy. However, in practice, it can be very difficult to manage behavior effectively. Some landlords have to balance very important interests that may be incompatible, and different people may have different standards for appropriate behavior. For example, some tenants may have different opinions about what constitutes excessive noise, or whether smoking within one's rented home is acceptable. Maintenance, repairs, and damage. These are consistently top concerns for both landlords and tenants. The most common disputes include what constitutes wear and tear as opposed to damage to property. For example, leaky faucets and burnt out lights versus holes in walls or damaged light fixtures. Pests, specifically who is responsible for the introduction and cost of control and removal from the premises. and hoarding, and whether the premises are reasonably clean or if a tenant has caused significant damage. At times, tenants and landlords may dispute over if a rented home is so messy that it requires costly cleanup and repairs. Notices. The Residential Tenancies Act requires landlords or tenants to deliver a notice to the other party in certain situations, but says nothing about what makes the delivery effective. We heard that people regularly make mistakes when delivering notices. People may suffer drastic consequences after a notice is deemed delivered by the sender, prompting the question of if there should be additional safeguards to ensure that the intended recipient actually receives the notice. We are publishing more reports cataloging issues with the Residential Tenancies Act, and we're making recommendations for improvements. Like and subscribe to get the latest news about all of our law reform projects, and visit www.alri.ualberta.ca to get the full reports.